Okay, it's Matt Reardon, the Oxford Outlaw. I'm back with another filing, something signature here with Writing with the Outlaw that I've begun to do a lot of. In fact, I've done it just about every single filing that I've made. I've released a video of actually reading the filing because a lot of people don't like to just sit there and read stuff, okay? This is a very interesting filing, and honestly, I'm not even through with it yet. I just wanted to go ahead and I wanted to release a piece of it. This stems from 4 subpoenas being sent out by Liz Crowder, well, by her attorney, Mona Pittman. In regards to the family court case, they are trying to basically jack my daughter out of my life, undeservingly. And this is all from Liz making false filings. This particular cause stems from Olive Branch Police Department picking Liz up on a warrant for filing a false report of rape back in November of 2018. They picked her up in January of this year. The warrant was cut back in, I think, January of 2019, and go figure, Lafayette County Sheriff's Department never picked her up in a year's time. She was arrested. She was taken in on this warrant in January of 2020. And since then, I have not seen my daughter, Lydia. There's court-ordered visitation in place where I'm supposed to get her every other weekend, I think like 5 in the afternoon until Sunday evening. And then the normal other visitation that comes with it. Haven't seen my daughter in a year. Over a year. I don't have an attorney. Quite frankly, I can't afford an attorney. All the mess that I'm dealing with right now, the fight with Writing with the Outlaw, I've yet to collect a single donation. I don't have an attorney representing me on any of that, and I've actually been making all my filings aggressively, fighting this fight on my own. I've probably filed over 300 pages of court documents over 2 to 3 months' time. I am now in 2 Supreme Court appeals. I've got a federal lawsuit filed against the city of Olive Branch and the state of Mississippi for the unlawful arrest that was made in regards to the false rape accusation, where the corrupt judge let her off with no jail time so long as she paid the fine in full, which benefited the city of Olive Branch 100% at the complete demise of the victim, myself. And also knowing that my child support money that is held out of my income went to pay to keep her out of jail while she is continuing to keep my child from me. Probably telling my daughter the most heinous of lies, especially being that she can lie to the court the way that she does. So anyways, they, after it looks like everything fell through for them, they filed a fraudulent petition with the Chancery Court. To make matters worse, they've ridden this lie out, and they have asserted the entire time the case is closed out with Department of Child Services on what she had tried to claim. Tried to claim that my wife had struck my child, and it never happened. My daughter even told them it didn't happen. And how somebody like this can continue on with their lies and continue to get away with it. I directly hold the state of Mississippi responsible for this, just as much as I hold her. Definitely directly hold her attorney responsible. Her attorney, Mona Pittman, played a significant part in everything that happened back in 2017. Liz and Mona Pittman together. And what you'll find out, and what you'll really start to see in this filing, is that they played an absolutely crucial part. They probably played the biggest part in everything that happened in 2017, and knowing that I'm trying to get myself exonerated, vindicated, and seek justice on the true criminals. Of course, that doesn't sit well with them, because they know that they're the biggest domino to probably fall in all this. So, I've got this filing. They have no right to get my... it's not like I have anything to hide. They have no right to get it. And it's about precedence. It's about putting my foot down. Because they cannot spawn a false petition, fraudulent petition, and then continue digging new rabbit holes trying to search for something, anything, to help justify their reason for being there in court for making that filing. So here it goes. Comes now before the court, Matthew Reardon, your confused, mentally anguished, and dumbfounded pro se defendant, and hereby with this motion moves this court to quash, suppress, and sanction the petitioner and her legal counsel after their continued insistence, through grabbing at straws one after another, to unfairly berate and overwhelm the defendant by continuing to go down additional avenues or quote-unquote rabbit holes. Defendant states before this court that this is precisely the case yet again, and the motive and reasoning behind the latest move by petitioner and her counsel to subpoena records of the defendant from 4 different law enforcement agencies should make it abundantly clear to this court that the petitioner and her counsel's sole goal at this point is to cause or create unnecessary delay in order to further harass and victimize the defendant on matters that the plaintiff and her counsel knowingly caused and or played a significant part in creating. There are several major issues at hand now, and this court has been made complete aware of in prior filings and motions, including, among others, the petitioner's attorney knowingly defrauding this court, as well as the defendant, through her filing of a fraudulent petition in which the notarized affidavit was duplicated and further used twice. The September 30th, 2020 petition filed by the petitioner attested to August 26, 2020, which was the original petition filed. The notary attested to the document from August 26, 2020, not from September 30th, 2020. This amounts to an incurable error, one that cannot be characterized as being a clerical error. This also happens to be one of very serious nature because of the liability that such careless and negligent actions pose on the notary public herself. Petitioner's attorney even had the audacity to not even so much as issue a response in the 10-day window allotted for response, further showing the willful and intentional efforts to write it out and to take it further by poking and prodding in other areas of the defendant's life, which not only she is not privy to, but she had no reason to ascertain based on the original petition that's been filed with this court. After all, this cause stems from petitioner's attempt to reduce even further the defendant's visitation with his minor child, whom he has demonstrated the highest levels of care for, and a psychological report from September of 2017 speaks to the professional opinion of such. This court has an obligation to look out for the best interest of the minor child and defendant asserts the most prejudicial of treatment counter to the obligation a family court is expected to provide. It is for these reasons that defendant moves this court to quash, suppress, strike, and sanction the petitioner and her legal counsel for their knowingly unethical and unscrupulous actions in trying to further tear down an innocent man, father, patriot, and veteran, whom for the entire time has clearly sought out equal protections of state and federal laws, the highest levels of care, despite petitioner's repetitive lies and false allegations on the defendant. Defendant has stated numerous times now in this cause that petitioners had a history of making false reports and that retaliation resulting from her being picked up on a warrant cut by Olive Branch Police Departments stemmed what all signs now show to be another witch hunt of the respondent, combined with the systemic kidnapping of the defendant's minor child for the past year. That petitioner went in gross contempt of this court's visitation agreement. Petitioners continued to bite the hand that feeds her through the perpetuation of libelous, defaming, and dangerous lies that are now clearly insistent upon the initiation of additional proceedings outside of this court, and Movant states most certainly warrants a criminal investigation due to the continued commission of crimes which have been directed at the Movant. While this constitutional crisis stemmed from the petitioner and her counsel along with the assistance of certain other John and Jane Does to be listed, it is the absolutely bizarre handling of this matter by local agencies and even the courts that have exacerbated this issue to it now being one that, quite frankly, has grown to levels the Movant never imagined he would see. Not immediately rebuking and condemning this sort of behavior and allowing petitioner to steadily play her guessing game and fishing for something to hang over the Movant's head has now taken on the face of fully condoning this type of despicable behavior. Sadly enough, it doesn't stop there, as the Lafayette County Sheriff's Department and Olive Branch Municipal Court have even gone so far as to target and even arrest the Movant, once again a USMC veteran, for seeking out protections of the laws in his full expectation to be afforded equal protections of the law under the laws of Mississippi, further outlined in Article 3 of the Mississippi Constitution and concreted absolute by way of the 14th Amendment of the United States Constitution, which Movant feels has been completely decimated over the past few months through the completely jaw-dropping criminal acts and the acts of condoning. Movant would assert an absolute necessity for a racketeering probe to take place and for the proper authorities to immediately intervene without delay in order to halt and deter the level of criminal conduct that mimics the exact same criminal conduct aggrieved in May of 2017, which Movant has gathered all evidence to prove beyond all reasonable doubt was a staged crime that never actually occurred, in order to silence, disarm, and get rid of the Movant due to the civil and criminal liability that certain private individuals, along with elected officials and government employees, directly brought about due to their malice choices and acts. The petitioner and her attorney, Mona Pittman, are in fact two of the most guiltiest of parties due to the extensive part they played in everything, which is why the petitioner's attorney went to the extent she went back in 2017 to shield herself, even though Movant has not had any contact with her outside of serving her a response to a court filing on May 8, 2017, which there is video evidence of. Movant puts Lafayette County and the state of Mississippi on notice of its grievous violations of not only its own state constitution and laws, but federal laws through intentional violation of 42 U.S. Code 1985, 42 U.S. Code 1983, and have flagrantly denied Movant the equal protections under state and federal laws, a key component of the 14th Amendment of the United States Constitution. Previous notices of violation have been issued by Movant, and the same criminal conduct involving knowingly false accusations alleged by the petitioner in this cause over the last 3.5 years continue. It is blatantly clear to see the end goal is exactly what Movant has asserted since May of 2017, that Movant's child has been used as a manipulation tool by her mother at the disposal of the defendant and through the help of agencies and courts.